Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5255, United States of America versus Fischer Law Firm LLC et al., Elizabeth McKay as joint official liquidators of Trade and Commerce Bank, and Gordon McRae as joint official liquidators of Trade and Commerce Bank at balance. Mr. Bono for the at balance, Mr. Bronstein for the appellate.
And please note that Judge Rogers is participating telephonically.
Good morning, Your Honor. May I please report? My name is Craig Bono, and I represent the appellates here, the liquidators of Trade and Commerce Bank. Through this appeal, we ask that this court reverse the district court's decision on a motion to dismiss, finding the interpleader that was filed originally in the Southern District of New York and through a variety of procedural steps made its way to the district court here in the District of Columbia, moot based upon a separate parallel 2467 proceeding, which is pursuant to a mutual legal assistance treaty recognized and authorized the United States to enforce a foreign criminal proceeding forfeiture order that was issued in Brazil. This case is very complicated. The procedure is very complicated. I'm going to attempt to identify sort of what I see as the most important points. Obviously, please let me know if there's some complication that is unclear to you and that would help you through this process.
Let me ask you a question. There was no appeal from the 2467 judgment.
Correct.
So that judgment forfeited the property to the United States and said any other claims against the property were in default.
Correct.
So why doesn't that moot the interpleader here?
Because, as I'll sort of walking through the Second Circuit opinion, what that process did was to provide Brazil a pathway to create an exception to the penal law rule, which otherwise prohibited their ability to establish their priority in the interpleader, which was filed far prior to the 2467 or any of those proceedings back in 2010. So, if Your Honor will indulge me, it sounds like you understand the procedure. I won't bore you with how we got to where we are. But the Second Circuit, on an appeal from the liquidators and a motion for summary judgment to Brazil.
I'm not asking about the Second Circuit case. I'm just asking about what is the effect of the 2467 judgment?
Right. So I'm attempting to answer your question because the 2467, the only reason it's relevant is because of the Second Circuit case. Because what the Second Circuit said was Brazil and the Attorney General, if you want to have any rights within the interpleader that we're opining on here, the one and only way for you to be able to establish those rights is to go get the 2467, thereby allowing you to, quote unquote, bypass the penal law rule that is otherwise prohibiting you from pursuing your claim in the interpleader, which is what the Second Circuit determined. That is why the 2467 was ever initiated. The only reason that any of this came up is because in the interpleader, in that appellate briefing, at the Second Circuit, one of Brazil's arguments was that there was an exception to the penal law rule established by merely the initiation of the interpleader by the United States. Because the United States and the Attorney General, as the executive branch, were speaking that it was fine for the judicial branch to determine whether or not this criminal proceeding in Brazil was a legitimate basis to establish a claim to the funds in the U.S. The Second Circuit said no. That wasn't enough to establish this exception. Instead, what you had to do was go through the 2467 process to establish the exception. What I think you're getting at is what I perceive to be a priority argument, which would be in the interpleader, Brazil is free to argue. Look, we have our.
But you're not answering. So my question though is why? So do you think the United States would have standing to bring an interpleader today after the 2467 judgment? Because to bring an interpleader, you have to have some kind of reasonable threat of competing claims. And after the 2467 judgment, would there even be jurisdiction
I
for the
absolutely
United States to bring in an interpleader?
I absolutely believe there would be, because in an interpleader, the question is, which of the claims has priority? One of the ways in which you establish priority in an interpleader is first in time. Right? Who had the first in time claim? Now, what?
Sorry, can I?
Go ahead.
I was just going to try to refocus you on the language of the June 2021 order, which, as Judge Rao pointed out, said your client's claim is held in default. Now, what do you think that, assume we know all of the background, and at least my concern is when that order came out, it says the property is forfeited, it may be seized by the US, and that your claim is in default. What do you understand that language to mean?
So as I've attempted anyway to try to answer, I think that language is an arrow in the quiver of whomever it is that is going to go forward and attempt to establish that their claims are legitimate based upon that 2467 order, in addition to the criminal proceedings that underlies. I think that's what and I'm not, I guess my point is, today we aren't here arguing that because the court, rather than allow us to argue that particular point in a priority discussion, which I think goes to many things, including the fact that under 2467, the relation back doctrine that you see in 18 USC 981 F and 18 USC 881 H, wherein when the United States forfeits property pursuant to either of those statutes, the title to that property vests in the United States as of the time of the underlying conduct, whatever it was that led to the forfeiting.
Right. So that's the merits argument you'd like to be able to make on remand in this case and interpleader about priority. And I appreciate it's a little bit odd that there was never a priority determination made except for the initial district court decision in the case. But it seems, maybe to sharpen this up, your basic theory is that all that happened in the 2467 case is that Brazil was granted a potentially enforceable judgment, sort of a potential right on par with the judgment that your clients had. But when I look at what actually happened in the 2467 case, we have the March 31 order, document 27, which seems to describe what you think was the end of that case. But then in the court's opinion, it says the government should now move for a final order of forfeiture. And they did, and you opposed that on the ground that you wanted explicit language in the final order saying that the 2467 order was contingent on the interpleader, right? And the district court rejected that and entered a final order of forfeiture holding your claims in default. And whatever else your clients hoped would happen, it seemed to me at that point, you had to appeal because what happened was a final order disposing of all the claims in the case. So what am I missing about that history?
Well, so I understand your question, and I understand your position. The answer is that the interpleader, the MLAT opinion can't be viewed in isolation and in a vacuum. It has to be viewed in the greater context of how we got to where we were in that situation. And the district, certainly the order says what it says, and we would be happy, again, to argue within the interpleader context what that means vis-a-vis priority. But I don't, what the order doesn't say is that the interpleader is now moved, right? That order didn't say that the interpleader was moved. What the district court did in this case, whenever it cited just the Second Circuit opinion to moot this on the motion to dismiss, that is what it cited to in footnote 1 in this case, to moot it, right? It said that the Second Circuit told it that it being the district court, that on remand, if Brazil went and got that 2467, that therefore the interpleader is moot. That is not what the Second Circuit said. And so while I understand your focus on what the MLAT order states, the Second Circuit's opinion is what should govern what happens in the interpleader itself, because that first of all, it's the law of the case. This is what has already happened in this case. The reason that there was no appeal is because the Second Circuit gave permission for the Brazil and the United States to go forward through that process, and that is how it played out.
So would your client have a claim against the United States outside of the interpleader? So say we affirm and find the interpleader is moot, would the liquidators be able to bring a claim against the United States in a separate action?
The answer is I don't know.
Okay,
But
so if the answer to that is no, then the United States isn't facing conflicting claims on this property.
right. So I said the answer is I don't know.
Oh, you said I don't
Sorry,
know.
I don't.
Okay.
Off the top of my head, I don't know the answer to that question. I think that as we sat initially, when the two competing judgments existed, if the United States had just given the money away rather than make an attempt to determine whether our judgment was sat equally with or in priority to Brazil, I think yes. I would have to do a little bit more research on what happens whenever there's several court orders that have happened in the interim as to whether there's a legitimate claim or not. But certainly, I think, but for having been ordered to do things by a variety of courts, there would have been a claim. I don't know the answer as I sit here today.
Right, but so I mean, I guess I asked you this question. I'm not sure if you answered it. Do you think the U.S. would have standing to bring an interpleader claim today after the 2467?
Yeah, yes, I do think that they would. Because if they had, for the same reasons that we think that we have a priority claim, because the claim to the funds.
I know you have a priority claim, which would be, as opposed to Brazil, but now title has been given to the United States. So from the United States side, not from the competing claimant side, I mean, would the United States have some reasonable belief that it would be subject to competing suits?
I do think so. And even in a 981 or an 881 case where forfeiture occurs, if third parties still have the right, even when title does vest pursuant to the Section F or Section H, third parties still have rights to bring their claims and say, wait a minute, we still should be allowed to pursue whatever rights I have against the asset because I'm an innocent third party and it's not fair that you're taking those assets away from the government. Here, 2467 doesn't have that language. So as a third party, innocent to all of the what was underlying the criminal forfeiture proceeding in Brazil, the liquidators absolutely have a right to this. Maybe the government has a separate view of how the Brazil's judgment should stand in relation to it, but both of them are legitimate judgments. One of them was issued by a Southern District Bankruptcy Court in New York in 2010. One was more recently issued by the District Court in the District of Columbia and the Brazilian Court in Brazil. And then a determination between those two should be made. And there is absolutely, I believe there is standing in order for the court to give that to a district court and say, please figure out which one of these two claimants has the greater claim.
One thing the government says is essentially that if you had a priority argument, you should have gone to the Brazilian court and made that argument there. What is your response to that argument?
Well, first of all, it's not clear that that's even would have been a possibility. But leaving aside whether it was a possibility or not, the funds that we were seeking to obtain in relation to the judgment that we have sat in the United States, held in a U.S. Marshal's account at the time. We brought our claim to the U.S. They then interpleaded those funds in a United States court, named us as the interpleader defendant, and asked the court to determine the priority of our judgment vis-a-vis everyone else. So we participated in that litigation all the way through the Second Circuit back and all the way to here. There's no reason why we wouldn't pursue the lawsuit and pursue the money where it sat versus having to go to Brazil and do. There's no into a criminal proceeding that we weren't party to, unrelated to what our judgment, having nothing to do with our judgment. It just wouldn't make any sense for us to have gone and done that there when we were already here, and so was the money that we were seeking to execute on. I think I have a minute and a half left for rebuttal. So.
Judge Rogers, did you have any questions?
Not now. Thank you.
We'll give you some time.
Thank you.
Good morning. May it please the court, Shai Bronstein for Appellee of the United States of America. This court should affirm the dismissal of the interpleader action because the 2467 action definitively disposed of the funds at issue in this case. The judgment in the 2467 action, which was not challenged, which is not on appeal, vested the rights and title to the Venus account in the United States. It declared it forfeit, and it held all other claims to those funds in default. There is no further relief that the court can issue in the interpleader action, and therefore it is moot.
So why can't, in the interpleader action, the court simply determine the priority? And perhaps the United States wins because of its 2467 judgment, but why shouldn't that have to be resolved in the interpleader court?
The reason for that, Your Honor, is that Section 2467 is a mandatory statute. It is a statute of exceeding deference, and it puts priority on the 2467 action. It says, for instance, in Section D, the most important language, that the court shall enter orders to enforce the 2467 action. It also cabins the judiciary's discretion. It says in subsection E, the court shall be bound by the findings of fact in the foreign judgment.
And so maybe that's all right, but why wouldn't that have to go back to the interpleader? I mean, this is a very peculiar situation because obviously, the United States brought this interpleader action during this sort of 6 months between Tiger Eye and the amendment to the statute allowing the restraining of funds. So it's a kind of a strange circumstance, but now that the interpleader has been initiated, why shouldn't it determine the priority?
Because of the nature of the judgment, Your Honor, in the 2467 action, the forfeiture order is a forfeiture order. It is an order in rem with respect to specific property. It is to be enforced per subsection C1 as if the judgment were entered in the United States. And so the court in its thinking can look to domestic forfeiture law and what an in rem process looks like. This is a process by which all of the rights to that specific property are decided exclusively in that action and as to the United States as against the entire world. So it is an in rem process and it is a forfeiture. Now, as to the argument about could they have brought claims, they absolutely could have and should have in the Brazilian action. The liquidators, as the record makes clear, did have notice since at least June of 2010, in fact, before the interpleader action was filed, that they could have brought a claim in the Brazilian action, and they were instructed about the ability to bring that in for their filings.
So let me ask you conceptually about mootness. So one way the interpleader can be moot is if there's no longer an injury to the United States, which is the party that brought the interpleader. Another way it could be moot is if there's no longer any redressability and the court can't order relief. And so I'm wondering which is the better conceptual way to think about mootness here.
You know, I think the court can approach it in either direction. There is no relief that can be offered by the court because what's being disputed in the interpleader action is effectively who gets these funds. The court in the 2467 action has already said the United States has them, they're forfeit. And so therefore there's no live controversy effectively that the court can grant relief on in the interpleader action. An interpleader action in this context is also incoherent because the very nature of an interpleader action is where the plaintiff stakeholder disclaims any right to the property that it is interpleading. Because of the 2467 judgment, which vests title in the United States is no longer a disinterested plaintiff stakeholder. It's now a very interested holder and has a claim to that property.
So maybe that is the better ground for mootness then, that the United States no longer has the type of Article 3 injury that makes it appropriate to seek interpleader.
Your Honor, the government believes that either path to mootness is equally valid. There does not seem to be a dispute, and so there does not seem to be relief that can be granted, and so there is mootness on that ground. But to
determine that there can't be relief granted, we would have to make a number of pronouncements about how 2467 works in this context, where there is a judgment for the liquidators from one court, and there's a 2467 judgment from the district court. And maybe perhaps perhaps it would be more minimalist to say, maybe it might be a more narrow decision to determine that there's no longer an injury here.
That would be a narrower path, Your Honor. We would agree with that because as the court raises, there is no longer Article 3 standing in the sense that there's no longer an Article 3 controversy because the United States would stand as both the plaintiff stakeholder and a defendant interest holder. And
do you agree that you need Article 3 standing for interpleader? There are not a lot of cases about this, and there are very few cases involving the U.S. seeking interpleader.
That's correct, Your Honor. We're not aware of any. There are very few cases, as the court will note, on both Section 2467 and interpleader in this context. And that's, of course, exactly the issue that the court has raised. This is a very unique circumstance where Section 2467 said one thing, Tiger Eye came and said the United States is interpreting it wrong. And then there's only about a 5-month donut hole between when that happens and when it gets fixed, which should show the court how important Congress understood that to be. That's a remarkably quick period of time to amend the statute to fix that issue. And so in this case, the 2467 action does definitively dispose of the assets unless there is one of 5 enumerated exceptions that the liquidators could have raised in that action, but chose not to. They could have raised the due process arguments, they could have raised the lack of notice and ability to challenge it, and yet they did not. In fact, the proposed order that Judge Garcia, you referenced earlier at docket 30, they effectively concede all of the enumerated exceptions to 2467. So they knew, the liquidators knew, that they were going to end up with this judgment that says that the property is forfeited. In fact, they almost asked for that by not challenging and not raising any of the enumerated exceptions to 2467.
You mentioned normal domestic forfeiture proceedings. And you said, I think, that essentially the forfeiture proceeding is dispositive and final. Are there any exceptions to that? For example, if someone just doesn't receive notice of the proceeding?
Of course, there are due process requirements baked into and as part of domestic forfeiture proceedings that ensure that potential claimants have notice to initiate a claim as against the potentially forfeited property. And so 2467 is actually a close analog to those due process protections in the United States. It requires that there be a system of due process, that the court have jurisdiction, that the judgment not be entered by fraud, and the potential claimants have notice. And so all of those were met here.
So is effectively your position is, and maybe we don't have to resolve these questions in this case, but that what 2467 envisions is that everybody with a priority claim would actually litigate that in the foreign court, not in a domestic court. And once we're in a 2467 proceeding, their only argument will be lack of notice.
That's exactly right, Your Honor. The liquidators could have brought that claim of priority in the Brazilian litigation. Brazilian law does allow for the relation back doctrine, just like the United States, and that was raised in several of the filings in this case. But the proper place to raise that challenge was in the forfeiture action in Brazil. The liquidators had notice of it. The liquidators acknowledged that they had notice of it, and they could have raised exactly that defense. So by the time the Brazilian government, Brazilian courts have issued an in rem forfeiture saying that this property is forfeit and title should vest in Brazil, all that's left for the 2467 action, because of this deferential language, is first for the Attorney General to decide whether that system was fair, whether it had due process, and then whether it's in the interest of justice in the United States to enforce that forfeiture order. Once the Attorney General makes that decision and certifies it, that decision in B2, subsection B2, is final and not subject to judicial review and not subject to administrative review. The court in subsection E shall be bound by the findings of fact of the foreign judgment. And in subsection D, the court shall enter orders to enforce. And so, as I said, section 2467 is one of exceeding deference. It's as if in subsection C, the US court had issued a forfeiture judgment. And so all of the concerns that the liquidators raise about priority or things like that, they're baked into the Brazilian forfeiture proceedings. And it's part of the statute to consider that those have to be available.
So following up on a question asked, I think, by Judge Rao, there is no interpleader action left, in a sense, in connection with this particular controversy? Is that the United States position? So it could not bring an interpleader action at this point?
That's exactly right, Your Honor. At this point, the United States has title to the property, and per the 2467 order, and per its treaty obligations and Section 2467, once the stay is lifted, it will transfer that property to Brazil.
Let me ask, I'm interested in your view of the question I asked the liquidators as well. If the interpleader is moot, would the U.S. be subject to a suit from the liquidators for this property? Could they be?
But I apologize, I couldn't.
I mean, if the interpleader is moot, do you think the bank liquidators could bring a suit against the United States for this property?
They would not have a claim against the United States. At this point, the United States has an in rem, it has a forfeiture of the property, and as the court held in the 2467, all claims to the property are held in default. And so that would extinguish the liquidator's claim as against the United States. And that is yet another reason why the interpleader action is rendered incoherent by the decision in the 2467 action. The United States effectively would have to stand on both sides. The property is no longer within the court's ambit because the district court has said that the property is forfeit, and there's no relief that can be granted. And so whether the court takes that approach as there's no relief or whether there's no controversy, the government's position is either way, it leads to the same conclusion. The action is incoherent and unconstitutional and should not be allowed to proceed because the court lacks jurisdiction.
So basically, you view the interpleader's concern here arising simply from the fact that it litigated this for years, had a judgment, and then the law changed. And of course, it says, well, the government changed its position, but.
So the government did not change its position about the interpleader.
No, I understand your position, but from the liquidator's point of view, there was a change, and the government says, well, we're simply following the law as it's now been articulated.
That's correct. I think there's two responses to that. The first is the government is following the law as it's been articulated in the change 2467, but also following the order of the Second Circuit, which was instructing the government about the penal law rule effectively. It required that if Brazil is going to bring its forfeiture judgment into the United States, it has to happen through 2467. And so the government, far from changing tactics or things like that, is simply following the Second Circuit's requirement in this regard. Now, in terms of the liquidators arguing, well, we've been litigating this for a long time, that may be the case, but they've been on notice for 13 years now that if they wanted to challenge the Brazilian forfeiture order, they should have done that in Brazil. That's baked into those proceedings. It's part of Section 2467. They chose at their own peril to litigate exclusively in the interpleader action, which now that there is a foreign final judgment, and now that the court has decided to enforce it and forfeit those funds, disposes of their claims. See, my time is nearly up. If there are no further questions, the government would respectfully request that the court affirm the dismissal of the Interpleader Act. Thank you.
I'll give you 2 minutes on rebuttal. Sorry? I said we'll give you 2 minutes on rebuttal.
Thank you. I'd like to just make 2 points and then answer any questions. One of the points is that both the government's, many of the questions here today and the government's position appears to be that once there's a forfeiture, the game is over for everyone. That is it, like fait accompli. But that isn't the case. And that's not what in fact, you can look to actual domestic forfeiture law to determine that it isn't the case, right? If it was the case that once a forfeiture occurs, that as to everyone else in the globe, the United States has greater title, then why is the relation back doctrine incorporated in both 981 through Section F and 881 through Section H, which vests title in the previous time than when the forfeiture occurred? Because you wouldn't need to, which improves the priority of the U.S. government, right? Winding the clock back improves their priority vis-a-vis anyone who obtained a claim in the interim between whenever the conduct occurred and when the forfeiture order was issued. That is why that relation back doctrine exists, to improve the government's claim to those funds. You wouldn't need to improve the claim if at forfeiture, that's it, the game was over versus everyone anyway. 2467 doesn't include that relation back. That is why the game isn't over and why we have to now go do a priority determination to determine whether the 2467 and the underlying criminal proceeding in Brazil governs and has priority, or the liquidators do. The other point I want to make is that while I understand that we spend a lot of time not talking about the Second Circuit opinion, it is the opinion that governs the interpleader, which is where this appeal sits. It is the opinion that describes how this whole process was supposed to play out. And in that opinion, it explicitly says that what Brazil tried to do the first time by asserting that the initiation of the interpleader was an exception to the penal law rule was to, quote unquote, bypass the actual exception to the penal law rule, which is the 2467 process. The only place where an exception even matters is if the rule itself is going to be applied. Otherwise, you don't need an exception because you don't have a rule. The only place the rule applies is the interpleader, because the penal law rule has nothing to do with the 2467. It's not a defense there. So for the exception, as the Second Circuit described it to matter, we have to go back to the interpleader. The liquidators have to say, penal law rule blocks you, which has already happened. Then Brazil or the United States has to say, wait, we have an exception to the penal law rule. Here's our 2467 that we did pursuant to what the Second Circuit told us to do. And now we should win. And then we will say, we should win. And then the district court should determine who in fact does win. That is how this should play out. That is the course that the government set in 2010 when they initiated this interpleader, and the course that the Second Circuit outlined in its opinion, and that is what should govern this court's decision on the motion to dismiss. Thank you.
Thank you. Case is submitted.
Case number 22-5155, Lassana Magassa, appellants versus Transportation Security Administration. Ms. Jump for the appellants, Ms. Valdivia for the appellee.
Your Honors, may it please the court. My name is Christina Jump, and I am here on behalf of the appellant, Lassana Magassa. The basic purpose of the Freedom of Information Act reflects a general philosophy of full agency disclosure, and FOIA's exemptions must be narrowly construed. This court held that in Epic versus DHS in 2015, and that holds true today. Unfortunately, the district court's ruling in this case does not reflect Congress's intent or this court's application of it. The assertion of exemption 3 in this matter by the government fails because there's an insufficient Vaughan index, which bears that title as a Vaughan index, but lacks the substance that the courts and the Freedom of Information Act require. Categories, as the government submits in its Vaughan index in this matter, must be sufficiently distinct under prison legal news. But here, the defendant submits one category for 182 fully withheld pages in one general category with no specifics that includes language like including some of these criteria and any comments which may be used, and does not reasonably identify the types of documents with enough specificity to meet this court's standard. In Summer versus Department of Justice, this court held that the Vaughan Index must describe each document or deletion and make specific findings as to how the exemption relates to each document. That did not happen here. In addition, the Blair and Miller declarations used may and could repeatedly throughout them. In Founding Church of Scientology, this court held that categories must be specific because each withholding must be specifically identified. The government retains a high burden because anything less would not meet the exacting standards of the Freedom of Information Act.
Ms. Jump, I mean, the Blair Declaration here gave a number of reasons and described the withholding in fairly significant detail. I mean, what more is the government required to say or do?
Your Honor, I believe that first of all, the Vaughan Index does not contain that specificity at all. And are you talking about the Blair Declaration or the Miller Declaration?
Yeah. Both.
The Miller Declaration gives extensive detail on the process and on the procedural history at the administrative level, but then jumps to more conclusory statements, and as does the Blair Declaration, which relies on the presumption, as the government does in its briefs as well, that simply stating the exemption applies should be entitled to deference without going into any specifics. We also argue in our briefs, and I'd like to present here, that the district court failed entirely to do a segregability analysis and did not address that at all. Both the Blair Declaration in footnote 1 and Appellee's response in footnote 7 reference that in-camera review would be available to more specifically show the applicability of the exemptions, but that did not happen at the district court level.
I just go back, you said that the Blair Declaration didn't have sufficient detail.
Mhm.
And so, for example, on exemption 3, it does explain that the one category of requested documents all relates to screening procedures. And then it says, if this material was made public, it could help or enable terrorists to evade those screening procedures. That seems logical and plausible. And so what more did they have to say to withhold all of the screening procedures?
Your Honor, I would say in response to that, that while there may be some level, and I don't doubt that there is some level at which details about the screening procedures should not be provided, there is also the compelling interest in the public understanding the processes and the procedures used by the government. And that's where a segregability analysis would come in to determine how much of it could potentially be produced, which would be relevant. Again, under Roth versus Department of Justice, this court held that agencies must still disclose all reasonably segregable portions of exempt records or of records which have exempt portions. And in-camera review is the appropriate way to identify this. Again, the public has a great interest in information which illuminates government agencies' methods, which is what we're looking at here. And we cite in our reply brief, as well as at the district court level, 2 examples and a string of representative cases, which identify why the TSA procedures, and particularly regarding DHS trip claims, is in fact something that is of the public interest, that is a compelling public interest to know. And so with that, there is, again, it is so essential that segregability occur as the District Court of DC held in Jarvik versus CIA, that segregability analysis is so essential to FOIA that the failure of that alone is remandable error. I understand there's a DC District Court, but it is consistent with this court's holding in Epic versus DHS and the other cases that we've cited here today as well. In addition,
So counsel, generally, that it seems to me you face a difficult burden anyway, given the nature of what the government does know about your client and what you have disclosed about your client. Given the long history and the repeated statements of deference here, what do you understand to be your burden in order to avoid these precedents? In other words, you can talk about segregability, you can talk about some of the other decisions, but why must the government do more than it did here when it knows what you have already disclosed about your client?
Your Honor, I would go to 2 points in response to that. The first being that, again, returning to Roth versus U.S. Department of Justice, that agencies still must disclose the reasonably segregable portions of requested records, and that agencies have the burden to show how privacy interests of an individual outweigh the public's interest in those records. And here,
there's no question about all of those generalities. The problem, it seems to me, you face in part is that those are well-established statements of law, and you have to overcome them in some way. And courts, including this court, have repeatedly affirmed the type of what you would describe as limited disclosure by the government in these types of cases. What is it that's unique about your client's case such that it would cause this court to either reconsider or narrow or recharacterize some of the statements that you have cited in our precedent?
Your Honor, 2 quick points in response to that. I would say that, first of all, the fact that it is our particular client and whatever his outside interest may be would have, under Perio, Peritiv, and Horner, no bearing on the outcome of this, as these documents, if producible, should be produced to any person who does request them.
No question about that. But you have years and years of precedent, not only in this circuit, but other circuits and the Supreme Court. And other than the very early general statements in Rose, et cetera, by the Supreme Court, what is it that takes your case out of the scope of these previous decisions? In other words, as Judge Rao pointed out and Judge Garcia pointed out, statements have to be viewed contextually here. And so the declarations, and these 2 declarants have been doing this for a long time, and sometimes we sent their declarations back saying they were insufficient. But it seems to me that that's a difficult burden, and you may be able to meet it, but we need something very specific.
Your Honor, in that regard, just very briefly, as I do note the time, but I want to respond to your question, I would say that Mr. Magassa here does identify his interest in understanding the procedures that affect him as well as many other people. He points to his substantial interest there. The government, again, tries to make the word substantial be a more minimal burden on itself, but in Niskanen versus FERC, this court held to the contrary, that does remain a burden, and that remand is the appropriate place really to do that segregability analysis and to get into the details. It may end up that all of the same information remains not producible or not discoverable through the Freedom of Information Act. But as it stands right now, with what he's requested, with the interest that he has shown, with the representative cases that we've identified that support this interest for the public, as well as for this individual who continues to hold a CETA badge, as we've referenced, and as opposing counsel, as my colleague across the aisle referenced in Appellee's response brief. So he has an ongoing, continuing interest in knowing what the TSA is looking at regarding him. as it does in fact directly affect his livelihood. That is something that I think separates this case out if needed, but in addition, there is the compelling public interest in understanding how the government works. And as this court said in Hall, he's seeking information that will tell him what the government is up to, which is the kind of information that does advance the public's interest and knowledge in how the government works. With that, I will respect the clock and come back hopefully for just a few minutes at the end for rebuttal. Thank you very much.
Good morning, and may it please the court. Diana Valdivia on behalf of the Transportation Security Administration, or TSA. I'd like to begin this morning with by addressing 2 points that were raised in the argument from my friend on the other side, specifically with respect to segregability and in-camera review of documents. My friend on the other side suggested that the court had erred in not making a segregability determination in this matter, or that there were not support in the agency's declarations to establish that the agency had conducted an adequate segregability analysis. However, the court below did make a segregability determination. It determined that the agency did in fact live up to its segregability obligations. And in doing so, it relied specifically on the Miller Declaration with respect to the Exemption 6 withholdings and the Blair Declaration with respect to the Exemption 3 withholdings. For those Exemption 6 withholdings, which had to do with the names of federal government employees from the TSA and from CBP, the Miller Declaration specifically states that the only thing that is under those redaction boxes are the names of the employees. So how that could be further segregated without violating the very privacy right that is at the heart of Exemption 6 is never explained by my friend on the other side. And in fact, since the Miller Declaration explains exactly what was withheld and that nothing further could be segregated from the withholding, which is only a name, the court found that that was sufficient to meet the segregability obligations. With respect to the Exemption 3 withholdings, there is also significant information provided in the declaration of Mr. Blair. And Mr. Blair was the individual at the agency who had the ability to determine what constituted sensitive security information, which is exempt per statute, the Homeland Security Act. And he described that he did a personal review, not only his staff, but also he did a personal review of the information that was being withheld. He determined that it all constituted sensitive security information, which was exempt, not that it was intertwined inextricably with non-exempt information, but that everything that was withheld was in fact sensitive security information. And the district court was relying on those paragraphs of those declarations from Miller for Exemption 6 and Blair for Exemption 3 when it made its segregability determination.
Talk a little bit about exhaustion here, the failure to exhaust, his challenge to the Glomer response and the scope of the search. So what in the government's view was Mr. Magassa required to do administratively that he failed to do here?
Well, Your Honor, this court has instructed in the Detman decision that issue-specific exhaustion is required in the FOIA context. And in fact, that's consistent with the agency's regulations, which instruct FOIA requesters who are appealing an agency's decision to specifically identify the issues, basically why they believe that the agency's production was insufficient. And here, Mr. Magassa, through his counsel, provided a 3-page letter which did meet that issue exhaustion requirement, and it did specify issues that he had with the agency's production. It nowhere put the agency on reasonable notice that among the issues that he was concerned with the agency's production was the adequacy of the search or the Glomar response. It was very detailed in its issues with the withholdings, those being 23 pages of records that were redacted and 182 pages that were withheld in full. And the FOIA officer receiving that appeal would not be on reasonable notice and did not therefore address in the agency's response the adequacy of the search or the Glomar response. So because those...
a little bit difficult because for the requester, because at that point, they obviously don't have the affidavits that come in later if there's litigation. And all they have is TSA's response. So just for example, the TSA response doesn't say, we are making a GLOMAR response. In other words, we certainly can't fault him for not using the words GLOMAR. And he does object to the general lack of specificity in invoking various exemptions. So I think I also have at least some question about what exactly he should have put in his appeal to challenge the GLOMAR response. Do you have a view on that?
Your Honor, I would like to direct the court's attention to the agency's release letter, which is an attachment to the declaration of Terry Miller and is in the joint appendix. The court's indulgence, I can give you the exact page number. It begins at page 56 of the joint appendix, and it does in fact specifically include GLOMAR language. This is on the third full paragraph down, saying to the extent that your request relates to records maintained by TSA, TSA can neither confirm nor deny whether an individual is on a federal watch list. This is the GLOMAR language. So the agency's response to the requester not only produced records, identified what was being withheld from the records that were produced, but also put the requester and his counsel on notice that there was a partial GLOMAR response. It was not a blanket GLOMAR response, but there was a partial GLOMAR response that to the extent his request relates to records maintained by TSA, TSA can neither confirm nor deny whether an individual is on a federal watch list. So if the requester and his counsel took issue with that, that could have been identified in their appeal. So they certainly were on notice at that time that that GLOMAR response had been issued.
But just a methodological question then. Would you, if we agree that his appeal fails on the merits of, for example, the GLOMAR issue, do we have to address exhaustion at all?
Well, Your Honor, because FOIA exhaustion is not jurisdictional, it is not a threshold jurisdictional issue that the court need reach, but the failure to exhaust should not or cannot be excused and by the court. So even though it is a jurisprudential doctrine, this court's decisions, which are interpreting Supreme Court precedent, make clear that when exhaustion is mandatory, as exhaustion is in FOIA, and we know that from this court's decisions in Oglesby, Hidalgo, many decisions of this court hold that exhaustion is mandatory in FOIA. Where exhaustion is mandatory, the court cannot judicially excuse it, even when it is.
Certainly couldn't reverse without addressing exhaustion, but we could affirm, right?
Yes, Your Honor, you could affirm.
But it's not discretionary exhaustion.
Exhaustion is mandatory under this court.
Right, because I thought you said that there was some discretion before you said it was mandatory, but you agree that exhaustion is mandatory. It's not jurisdictional, but it's mandatory.
Correct, Your Honor. Exhaustion under the FOIA statute is mandatory. It is not jurisdictional, it's jurisprudential. But this court does not have the opportunity to excuse a failure to exhaust under this court's decision in Fleming. Even jurisprudential exhaustion, if the statute makes exhaustion mandatory, it cannot be judicially excused. Here, there was some exhaustion, but there was not exhaustion of all issues, and this court should not excuse the failure to exhaust those issues.
Exhaustion is jurisprudential. Are you saying it's not statutory?
It is statutory. However, it is not jurisdictional. This court's decision in Hidalgo explained that because the statute does not make it so, it is not jurisdictional, it's jurisprudential.
So you're saying it is a mandatory statutory exhaustion requirement?
Yes, Your Honor.
Okay.
It is. It's just not a jurisdictional one.
Thank you. Any further questions? No? Judge Rogers, any further questions?
No, thank you.
Thank you. Then the TSA would request respectfully that the court affirm the judgment. Thank you.
Thank you.
Thank you, Your Honors. I'd like to address 2 points that came up. First of all, that the district court properly held that there was exhaustion to the extent that it is required in Joint Appendix 65. There was the statement, we further appeal the agency's lack of production in response to Mr. Magassa's request overall, as noted by the district court at Joint Appendix 132 to 34. And as appellees recognized on page 29 of the response brief, that there was an argument to segregability at the administrative stage. Whether they construe that to be something that was properly worded or not is not the examination, is not the test. As this court knows, there is no requirement of technical precision under Institute for Justice versus IRS.
Ms. Jump, can you point us to where there was a challenge to the Glomer response and to the scope of the search?
Where there was,
Where Mr. Magassa raised the challenge administratively to the Glomer search?
okay.
Or to the scope of the search, like in the record, not in the district court's opinion?
Yes, Your Honor, again, I would point to at JA 65 and then additionally in the pages of the specific request, the request in each letter, but where Mr. Magassa consistently and repeatedly narrowed the search in response to the objections by the TSA. Each time it stated that he was not abandoning his entire search, he was not abandoning his entire request, and that he did continue to issue the full request, was only complying with what the TSA instructed was needed to perfect the request. And in the appeal letter stated again that it was specifically, he was specifically appealing the lack of production as a whole and overall, and then also went into specific points. Appellees take issue with the language that says further, this is a request overall.
Don't our precedents require issue-specific exhaustion?
They do, and we believe that the language that is included does address that. Again, there is, he can't know specifically what records exist, and there is a duty to construe liberally all of the requests. But again, we do stand on the requests that say that he did not abandon any part of his request in the appeal. He continued to appeal that that the agency lacked its production in response to his request overall. And as the district court held, and based on the specific letters, we believe that that meets the requirements here. I would state also that under prison legal news, the identity of the requester and his intended use bears no relevance on whether the information is producible or discoverable through the Freedom of Information Act. And finally, that as this court held in Niskanen, the release of names is not automatically always protected and determined to be a sufficient threat. There must be a connection shown to show why there is a sufficient threat in the simply by producing names. We're not asking for like addresses or other identifying information, but simply asking for the names, and that there has to be something that shows that it is clearly a threat to the individuals.
Ms. Jump, I see you're out of time. If my colleagues have no further questions.
Thank you, Your Honors. I appreciate that.
Case is submitted.
Case number 23-1025 et al. Troutbrook Company LLC, doing business as Brooklyn 181 Hospitality LLC, petitioner versus National Labor Relations Board. Mr. Iran for the petitioner, Mr. Said for the respondent.
Good morning. Please, the court.
I'm Thomas Eron of Bonchenick and King on behalf of Troutbrook. We're here asking the court to deny enforcement of an order from the National Labor Relations Board. The case presents two interrelated questions. First is, there's substantial evidence in the record as a whole to support the finding that our hotel insisted indefinitely on the resolution of all non-economic subjects before negotiating economic subjects in the collective bargaining for a first contract. And the second question is, what caused these negotiations for a first contract to break down? As the administrative law judge found, much of the record of bargaining here is in writing. Parties were negotiating during COVID. They were all telephonic communications, and there were detailed bargaining notes, as well as multiple emails between the principal negotiator. And this record is focused strictly on the bargaining. There are no allegations of unlawful conduct outside of the bargaining, no claim of unlawful threats or unlawful changes to wages or terms of employment, no discriminatory treatment of union supporters, no other evidence of animus to the union. And we must recognize that these negotiations occurred in the context of the COVID pandemic in 2020. And as relevant here, that had a devastating effect both on the hospitality industry in New York City and then on this particular hotel, which is a small independent hotel.
Mr. Aaron, can I ask you to focus your factual arguments under the pretty demanding substantial evidence standard?
Certainly, Your Honor.
Mm-hmm. So how do you overcome that?
I think there are two key big picture points and then some very specific points. In terms of big picture, we have a decision. We have a split decision from the labor board. One member dissenting, and there is a concern that the board did not fully, the majority did not fully evaluate the totality of the circumstances. In particular, did not appreciate, did not give consideration, appropriate consideration to the interplay in the collective bargaining. The union's position from day one was that it had a master agreement. This document, over 100 pages, covers multiple subjects. And the union insisted that the company provide a complete response. In the ALJ's decision, she was in her recitation of the facts, she recites 18 different times when the union demanded a complete response. And the board failed to evaluate and consider appropriately the impact of that approach to bargaining. In any bargaining, there's a trade-off one side to the other, and what one side does affects the impact of the other. And the failure here on the board's part was in not considering the union's conduct and the consequences. So, for example, a very specific language that the board uses to find a violation is that the employer insisted indefinitely on the resolution of all non-economic subjects before negotiating economic subjects. There was no insistence here. The employer initially proposed a ground rule, but modified that to allow simultaneous discussion. It's not even an appropriate description of the employer's position to say it was non-economics. The employer's proposals included a proposal on overtime pay and a proposal on work schedule, which are critical to the economics of the business, not simply non-economic subjects. It didn't persist indefinitely on this position. This negotiation was just getting started. There were short introductory discussions that were cut short because the union insisted that the employer was obligated to provide a complete contract proposal. And
I think just on, so for example, given the substantial evidence standard, the board did explicitly find that the union did not present the IWA on a, as they put it, a take it or leave it basis, and repeatedly emphasized its flexibility with respect to both economics and contract wording. So certainly that was their initial proposal, but there's a lot of evidence in the record about how the union offered to make adjustments and have an MOU that adjusted to Troutbrook's circumstances. So how can we sort of accept your view that the union was doggedly insisting without any flexibility on the full IWA in light of the board's findings?
there's no question that the approach that the company took here was a legitimate approach. In fact, the union's negotiator, Mr. Martin, conceded that he had seen this approach before. He recognized it as a reasonable approach. And the company's goal was to get a simple, clear contract. The union's approach was to bargain from this document. And if you add a rider to a 100-page document, you just have a longer document. You do not have a simple, clear collective bargaining agreement. So the two approaches were completely inconsistent. And the record is very clear that the union said there is a legal obligation for the company to provide a complete response. We are stopping negotiations, going to the labor board. We want to get a ruling on that issue. And when they went to the labor board, the general counsel chose not to pursue that issue. That is not the basis for the decision here. And that's what caused this negotiation to fall apart.
Right. So the unfair labor practice that the board found is a refusal to bargain over mandatory subjects of bargaining. So I understand the possible exceptions of overtime in the other example you mentioned, but it seems to me one simple question is, did the company ever engage on or give a counter proposal on, for example, wages, retirement benefits, or health benefits?
It did not, Your Honor. However, it did present several significant proposals, and the union chose not to make any counter proposals on those individual proposals. And I would submit to you that that's a critical difference between the precedent that the board is relying on. Examine those earlier cases. In each case, there was a back and forth, a give and take. The best example, frankly, is the patent trader case, where it was a new contract. The union came in with a standard area agreement. When the employer objected to that, they began negotiating over specific issues. And there was back and forth. There was a counter proposals from the union. They moved off of their master agreement.
So, Mr. Is your position also that the board's decision here is arbitrary and capricious and contrary to law?
Our position is that it's bad labor policy, Your Honor, because it sets up a situation.
Bad labor policy
Yes.
under the statute, or?
Yes. That it is.
I mean, we're not here to enforce labor policy. We're here to enforce the law.
Right. I understand, Your Honor. But as we're evaluating the legal consequences of the board's decision, it's fair to recognize that it puts in the hands of a single party the ability to demand a complete response on all issues early in the process. That is going to thwart the ability to reach agreement.
Is the legal problem with that it's inconsistent with board precedent, that it's inconsistent with the NLRA? What is the legal argument?
That it's inconsistent with the purpose of the statute, which is to support and encourage collective bargaining and the resolution of disputes. And this rule of law does not achieve that result.
Is there a specific provision of the NLRA that you believe the board has violated here?
No, Your Honor, that's not the point that we're making. The underlying goal in this is to determine whether the parties have an intent to reach an agreement. And we submit that the company's approach was consistent with that intent, and that there's nothing outside of the bargaining or within the bargaining that would lead to the conclusion that they acted in bad. And as we analyze the impact of the board's decision on this overall goal of statute to achieve labor peace, this decision takes us in a direction that's going to make it more difficult to achieve consensus, reach compromises, and avoid labor disputes. So we would ask that the court deny enforcement of the board's order.
Could I just ask one last question?
Yes.
You referenced the impact of the pandemic. And I just want to make sure I understand the argument, because to the extent the question is, if we thought there was otherwise evidence that the company did not engage on economic subjects, I of course understand the pandemic created a lot of uncertainty, but maybe that would just create good conditions for the employer to insist on very lean economic proposals. Is your argument that somehow the pandemic justified postponing discussion of those subjects entirely? And why would that be?
That's not our argument.
Okay.
There are two elements that I think are relevant from the pandemic. The first is there was a great deal of upheaval in the industry and at this employer. At the start of this process, there were 30 employees in the bargaining unit. By the time they sat down to do the negotiations, it was down to 8. In the course of all that, there was no claim that the union supporters were adversely treated or treated unfairly. And the second point is that this is a small hotel. It was a very difficult time for the hotel, and the negotiation process stalled, and not robust in the way that it would have been in a more normal economic environment. The management of the hotel was worried about keeping the hotel going, and these negotiations did not proceed far enough to make the judgment that the board made here.
I see. Thank you.
Thank you.
Good morning, Your Honor. David Side, the Labor Board. 2 initial points. First, the record amply supports the board's finding that the company unlawfully refused to bargain over economic terms until non-economic terms were resolved. That evidence, which includes numerous statements made by the company during bargaining that are summarized at page 35 of the board's brief, repeatedly referenced the need to resolve non-economic terms first.
Well, what about the fact that the board here doesn't seem to have taken into account the union's conduct? I mean, the union had its own particular bargaining position, which is that it wanted to start with the IWA. It wanted a counter proposal to that. Obviously, the hotel had a different bargaining position. So, I mean, if the board's responsibility is to take into account the totality of the circumstances in the negotiations, isn't the failure to completely, to totally disregard what the union did,
Your Honor,
make the decision not supported by substantial evidence?
Your Honor, very simply, the board did not ignore what the union did. What the company has presented to this court is basically an alternative view of the facts, but it hasn't shown that the record compels this court to come to a different conclusion. And so with respect to the argument made about the union's conduct, the board first very reasonably noted that the focus is on the company's conduct because it has a statutory obligation under the Act to discuss terms such as wages of employment and of wages. And the board then, however, did very specifically consider the union's conduct at page 331 of the appendix or the board's decision. The board looked at what the union did, and it did recognize that, yes, initially the union did want the company to accept the IWA as it existed, but it then suggested, well, if you don't like the IWA as it's written, we can make as many changes as you want to it, at least use it as a basis so we're talking the same language.
Right, but the hotel rejected that bargaining position as well. They didn't want to start with the IWA. They wanted a much simpler, pared down, shorter contract, which is my understanding that is well within its rights under the NLRA.
Absolutely, Your Honor. But then the union in the alternative said, okay, if you insist on starting with an entirely new contract, at least give a proposal on a holy trinity of issues, the main terms and conditions.
Well, again, that was
wages.
a bargaining position. It wasn't that the hotel was then required to do what the union asked.
Your Honor, it's required under Section 8D of the Act to specifically discuss terms such as wages. And what it cannot do, as it did here, is to
But
say,
it didn't
well,
have to present a counter proposal as the union demanded,
Your Honor, but what it
like a
can't.
full counter proposal.
Correct, it didn't, right, and that's correct. And so the board did not find that the union, that the employer violated the Act by failing to submit a complete counter proposal. And so, for example, and hesitant to make a hypothetical here, but could there have been a situation, one of the things that the company is trying to argue is that basically negotiation short-circuited. Had the company come back with a full wage proposal, and the union still said, well, not good enough. We're not going to consider your full wage proposal until you give us something else. Then could it arguably be a different case? Possibly. But that's not what happened here. The union repeatedly stated, look, accepting that you as a company want to start with an entirely new contract, we don't think we have to go that way, but if that's what you want to do, at least give us something and start with something like wages and benefits, really the elephant in the room. And the company's response was continually, even at the last bargaining session, the second to last bargaining session, non-economic first, and then eventually after we settle those, we'll get to economic.
Well, I mean, both sides were being intransigent to some extent. They both wanted to start from different bargaining positions. And the Act specifically says that, obviously the employer has an obligation under Section 8D, but such obligation does not compel either party to agree to a proposal or require the making of a concession.
Correct, Your Honor. It doesn't require a concession, but it does require to at least discuss the terms.
Well, would it not have been a concession to start with a proposal the way that the union wanted?
Your Honor, if the parties agree to discuss non-economic terms first, they're welcome to. When the parties do not have such an agreement, it is unlawful for an employer to insist on resolving the non-economic terms until it will even make or discuss economic proposals. And that's what the company did here. And just briefly touching on the pandemic, the company never argued to the board, and I think it acknowledged that argument this morning, that the pandemic in and of itself provided an excuse for not providing proposal on wages and benefits. And as the board did note, to the extent it is being relied upon, council made abundantly clear from the very first session that it simply bargained in the process of starting with non-economic first. It did not even, to my knowledge, even raise the pandemic initially. And there's no question that while the pandemic had an effect in bargaining and it led to the hiatus, I would simply note that the hiatus and the pandemic affected all the parties. It affected the employees who had voted at this point for union representation several years earlier that have obvious concerns as to whether their wages might be frozen or cut. It has an impact on the union because when bargaining does resume, the certification year has essentially ended. And at that point, if the employer has a belief that the employees no longer support the union, it has the ability to just simply walk away. So it affected everybody, not just the company.
Can you point to other board precedents where there's been such a short time of bargaining? I mean, here there was, everyone acknowledges a 7-month or so, I think, hiatus, right? So the actual time of bargaining was a few months over, a handful of sessions. And it seems to me that the precedents where, there's some finding of bad faith, usually involve many more bargaining sessions, many more hours of bargaining, many more months of bargaining. Here, in some ways they had sort of just gotten started in a sense. And so how is the board's decision here consistent with its precedent?
It's consistent. So cases such as First Student, which is cited in the board's brief, there were about 6 bargaining sessions over 8 months. Sunbelt Rentals, there was bargaining over about 4 months. But one of the things I would also point out here is that even in some of these cases where the board found a violation, what typically happens is a union will make an entire proposal as a union did here. At that point, the employer may take the position that it would prefer to discuss non-economic subjects first. There's no formal agreement that resolution has to be reached. And in response, the employer, and even in some of these cases where eventually a violation was found, the employer comes back with a full counterproposal on non-economic matters. It accepts a lot of what the union proposed and makes some minor changes.
So is the board's position here that employers have to do this when presented? When the union says we want a full counterproposal, employers have to do that? Is that the bottom line of the board's decision?
No, again, the board did not.
Because there are several things you said here in argument that suggest this is the board's position. Which suggests that Chairman Ring maybe have been right in his concerns about the majority's opinion.
Not at all. That is not what the board's decision suggested or that council is suggesting this morning. Simply noting that here, the union repeatedly expressed to at least get a proposal or a discussion about wages and benefits, the elephant in the room, and that even in situations where employers have been found to eventually have violated the act by not providing or discussing an economic proposal, oftentimes the employers in those situations do a lot more than the company did here by making, at least on non-economic terms, a somewhat comprehensive proposal, which the company didn't even do here. And that's all I'm suggesting, but it's not in any way suggesting that the company was required to, at the first bargaining session or the second bargaining session, provide a full counter proposal. The board is that.
What about the third or fourth bargaining session?
No, or even the third or the fourth. Again, it's a case-by-case basis as to at what point did a employer violate the act by failing to discuss economics. And on the facts of this particular case, when it hits the 5th bargaining session and the union has been pleading for, at minimum, if you want to present your own offer, your own contract, at least give us something about wages and benefits. The company responds, intending to negotiate over a subset of non-economic subjects, then move on to another subset, and ultimately move on to economics. At that point, whether it was 5 sessions or 20 sessions or 30 sessions, the board could very reasonably find that the company was refusing to negotiate over economic subjects at a situation where it is impacting and preventing bargaining.
So does that mean, what if they had just said, let's talk a little bit about the union's proposal on health benefits and had, to some extent, a discussion and expressed concerns about that? Would that be enough to yield a different outcome, and why?
Your Honor, again, on a case-by-case basis, but if the employer had started to indicate a willingness to engage the union on the economic subjects, it very well could have a different result. But it made absolutely no attempt in this case, as it admittedly stated both an argument this morning as well as in the court. Unless this court has any further questions, the board would simply ask that the court enforce its order. Thank you, Your Honor.
I'll give you 2 minutes on rebuttal.
Thank you, Your Honors. Just briefly, counsel for the board referenced the Sunbelt case. There were significant that was short bargaining. There were significant actions by the employer demonstrating an anti-union animus case that has clearly distinguishes it from the present case. And I think we need to be clear on the record as to what the union's position was. There is substantial evidence that it requested a complete response, and it did not provide any counter proposals unless and until there was a complete response. I respectfully submit to counsel for the board misstated the union's position that it was only looking for a response on wages or benefits. That has no support in the record. And we would, again, renew our request to the court deny enforcement of this board order. Thank you very much.
Thank you.
This adjourned November 3rd at 9:30 a.m.